The information provided in this episode is provided for general informational purposes only and may not reflect the current law in your state or country. By watching and listening to our episode, you understand that no information contained in this episode should be construed as legal advice and no attorney-client relationship between you, the host, or guest. You are advised to seek legal counsel concerning your legal question or concern from a lawyer licensed in your state, country, or appropriate licensing jurisdiction.
What will happen if you passed away and you did not have a will, or at least your will was invalidated? Meron ka ngang will, dinownload mo from the website, hindi mo na check na hindi pala compliant yon sa state law, especially here sa Texas, na invalidate ngayon yon nung namatay ng tao, nung pinoprobate na, nakita na hindi pala siya compliant, so mai-invalidate siya. So, ano mangyari? So, the person, as if the person passed away without a will. So, papasok ngayon ang intestate succession. So, doon niya marinig yung intestate succession pag ang tao passed away without a will. Okay? Ibig sabihin, wala siyang kasulatan na kung kanino niya ibibigay ang kanyang mga properties. Intestate succession is governed by state law. So, if you are in a different state, you're not here in Texas, it's always advisable to consult an attorney who practices intestate succession or probate or estate planning in your jurisdiction, so that you will get the proper guidance and the understanding and knowledge of the law, so that you know what to do in case you are in this kind of situation. Dito sa intestate succession, hahanapin yung next of kin. Okay? Kaya minsan kapag meron akong pinoprobate, because when we probate a will, or let's say a person passed away without a will, we apply for determination of heirs. Who inherits the property? Na ngayon, ito na yung mga unmarried person with children. Yan. Siguro, tignan natin yan. Unay mo natin yung yung if the person passed away na single siya, at wala siyang, at may mga anak siya, syempre puntahin sa mga anak niya, di ba? So, dito naman, this person is unmarried, okay? Pero may mga anak. Nangyayari ba yan in reality? Of course, nangyayari yan in reality. May mga, when we say unmarried, yung mga hindi sila nagpakasal, meron tayong mga common marriage, na hindi pa na-declare. So, unmarried pa sila, but they have children. So if in that case, of course, if you are not married and you are survived, you passed away and you're survived by your children, then your children will get everything that you own. Okay? Because in this case, kung you are unmarried, there's no community property, only your property. Everything is yours. Okay? There's no separate personal property. There's no separate real property. There's no community property to speak of. Everything goes to your children in equal share. Now, if one of your children is no longer alive when you pass away, at yung anak mo na yon who predeceased you, so that's the term, predeceased means namatay before you, nauna siya, ay meron siyang mga anak, so that means meron kang mga apo, then yung mga apo mo na will also get what the parent who passed away is supposed to get. So, hindi naman talaga sila mapag-iiwan na nawawalan talaga. So, that is if you are unmarried and you have children. Married person with children. Nangyari ba to? Of course, marami dyan, di ba? There's a lot of people there who are married and they have children, and sometimes they have multiple marriages and they have children from previous marriages and then from the current marriage. So, yon, medyo little complicated yan kapag you are not prepared. You don't have a estate plan in place. So, dyan na nagkakaroon ng medyo magulong settlement. So, especially if their relationships are not that great. Hindi naman lagi silang yung children mo from previous marriage okay dun sa current marriage mo, 'di ba? So, kaya nagkakaroon, especially if the relationship is not good. So, yan. So, tingnan natin. So, let's say you're married and you have children. Okay, so let's look at the current spouse, the current marriage. So remember, if you're married, you have to classify the properties na, because Texas is a community state. So that community property state. So that means if you are married, you have community property. And not all will be your community property, diba? You may also have a separate may also have separate properties. And when we say separate properties, you have to classify again. Is a separate property personal property or real property? If the person is single, okay, ito na yung mga single at hindi sila at wala silang anak. So kanina we talk about uh, unmarried, could be single, at may mga anak. Ito naman single pero walang mga anak. So ngayon, kanina mapupunta yung estate niya according to Texas law under interstate succession. Okay, so look at this. If the person passed away with no children, una mo na yan, remember, we are not going to classify whether the property is community property or separate property because hindi naman siya nagpakasal. So single siya. So mapupunta 'yun sa at wala siyang anak, 'di ba? Kasi una mo na 'yan, you will look into the downline. So baba ka muna, tingin ka muna sa baba, look at that. Do you see any descendants there? Descendants again, children or grandchildren. Pag wala, you go up. Okay? So, pag both parents are still alive when that person passed away, then the father and the mother will receive the equal share of everything. Okay? Equal share yan. So, mapunta sa parents mo yan. Pagka wala kang anak, wala kang descendants, there's nobody down the line there. Okay? Sometimes, by the way, we call our children then descendants and or issues. So, wag kayong maguluhan doon. It's the same thing. They're the same thing. All right. So ngayon, what if one of your parents is no longer alive? Nangyayari ba to? Of course, nangyayari to in reality, di ba? Minsan nauna ang ating tatay, our father, or sometimes yung mother, So kung wala sila, kung parehas lang buhay, hati sila, equal share. Pero kung isa lang ang still alive when the person passed away, then it's either the father or the mother. No, I just put there the father. So the living parent, siguro na lang gamitin natin, will get half of everything that you own. Okay? And then the other half will be received by your living siblings, yung mga kapatid mo. So kung meron kang 3 kapatid na buhay at the time the person passed away, half of that will go to the father or to the mother, whoever is alive, and then the other half will be divided equally among the living siblings. Okay? Now, question is, kung let's say yung meron kang kapatid na hindi na I mean na who predeceased you na namatay na before you, pero meron siyang mga anak. So that means meron kang mga nephew, nieces, yan. So sila naman ang magre-receive ng dapat doon sa kapatid na namatay na. Okay? So meron pa rin 'yon. So don't worry about yan. Kung ikaw ay pamangkin or pamangkin, niece or nephew, then you will be receiving what your deceased parent is entitled kapag kapatid yung namatay. All right? So that's another thing, another important distribution there. Karon ng complication kapag may mga other children, other children from other or previous marriages, diba? Let's say for example, meron siyang first marriage and meron siyang mga anak doon. Children pa rin 'yun. Kasama sila diyan sa separate, yung sa hatian na 'yan. So, kaya naging complicated yan pagka hindi magkakasundo, di ba? Siyempre, the best pa rin yung you come up with an agreement how to settle your estate. Otherwise, Texas will say who's gonna get what, okay? So, that will be separate real property and separate personal property. It's different naman pag community property, okay? Ito naman, what if this is your situation? You're married, but you have no children. Nangyayari ba ito? Of course, nangyayari ito, no? May mga spouses na hindi nagkakaanak or let's say no, their child passed away at a very young age, no? Sila na lang naiwan. So paano na yung nito distribution kapag walang anak? So again, because you're married, you'll have to determine whether whether the property is personal, separate personal property, separate real property, or community property. Okay, so let's look at this. If there are no children, meron ka lang spouse na naiwanan, um, if it's a separate personal property, then the surviving spouse will get everything. Walang anak, remember? So mapupunta lahat sa surviving spouse yung separate personal property, mga jewelries, mga um, heirlooms yan, yung mga personal items, expensive collections, yan. So mapupunta sa'yo yan. Also, mapupunta rin sa surviving spouse lahat ng community property kasi wala kayong anak eh. So, if it's your community property, the surviving spouse will get everything as well. Now, nagkakaroon lang tayo ng different distribution if it's a separate real property. Okay? Separate real property. Kapag of course, kung ang surviving, ang naiwanan lang naman, ang naiwanan lang naman na heir mo is yung spouse mo, then the spouse will get everything, right? Pero kung in this case, yan, iba-iba, no? So, kapag meron kang surviving spouse, okay? And then meron kang parents, remember wala kang anak. So half nung separate real property mo mapupunta sa surviving spouse mo. And the other half ay mapupunta sa surviving parents nung deceased person. Okay? So hindi lahat mapupunta sa asawa mo. May mapupunta yung kalahati na mapupunta sa sa magulang nung asawa mo. If they're still alive at the time of death. Okay? Ngayon, kung let's say both parents are alive, okay, and then the spouse survived you, then this is just simplified, so the spouse will get half and then yung other half paghahatian ng mom and dad mo. Okay, so half yan. So ganun nangyari. Pero kapag let's say isang parent mo na lang ang naiwanan, okay, so half will go to your surviving spouse. Tapos yung kalahati, paghahatian ng surviving parent mo at saka ng mga siblings mo, mga kapatid mo. So, mangyayari, 1/4 na mapupunta doon sa surviving parent mo, kasi isa na lang siya, and yung other 1/4, paghahati-hatian ng mga kapatid mo. That's what's gonna happen. Yan ang mangyari. And remember, this is only separate property. So, hindi naman lahat yan. Okay, ngayon, kung wala namang parents, ang naiwanan lang yung spouse mo at saka mga kapatid mo, then half will go to your spouse and then the other half paghahati-hatian ng mga kapatid mo. Okay, so that's how it's gonna work. Now, lastly, may tanong na, lahat ba ay subject sa probate? Lahat ba subject sa distribution dito sa interstate succession structure ng Texas law? Hindi naman lahat. Meron tayong tinatawag na non-probate assets. So may mga assets na hindi mo na kailangan pumunta sa court or hindi na kailangan ng administrator para, alamin kung kanino mo pupunta kasi meron ka nang nag-designate na beneficiaries mo dyan, okay? Like for example, ito nga, joint tenancy with right of survivorship. So meron kayong biniling bahay, let's say meron kayong property, although pinili nyo during the marriage, and could be a community property, pero you entered into a joint tenancy with right of survivorship with your spouse, ganyan. So when we say right of survivorship, automatic yung transfer ng ownership pag namatay ang isa. So let's say husband and wife, bumili sila ng property. O let's say, wag na lang husband and wife. Sabihin mo, ikaw and then yung friend mo. Hindi mo man ka mag-anak, You purchase a property, tapos dun sa agreement ninyo, dun sa contract, there's a right of survivorship. So, pag namatay ka, automatic mapunta dun sa kaibigan mo yung lahat-lahat. Okay? Wala nang gagawin pa. It doesn't have to be proven in court. Okay? Because the document says so. Okay, ganun yon. Now, the other one is living trust because you already, in a trust, if you create a trust, you already designated there your beneficiaries. So, mapupunta yon sa, sa mga dinesignate mo na mga beneficiaries doon sa trust mo. The other one is life insurance proceeds because when you sign up for your life insurance, meron kang you designated beneficiaries there. However, if let's say you don't have an alternative, na wala na yung beneficiaries mo na nauna siya namatay sa'yo, wala kang alternative, mapupunta yun sa estate, mapapasok yun sa interstate succession. Kaya importante meron ka mga alternates diyan sa life insurance mo. The other non-probate assets are funds in your IRA, 401k, and other retirement account. Why? Because you already have designated your beneficiaries there. So kailangan lang you have to prove that the person passed away through the presentation of that certificate. And also payable on death bank accounts yan kasi you designate there sa document ang beneficiaries mo. Basta meron kang designation of beneficiaries, and the beneficiaries at the time of your death is still alive and willing and capable of receiving it, then it's not gonna go to your it's not gonna go under interstate succession. It will be a non-probate assets. Yeah, let's say that you're able to determine there is no will. So now what do you do next? You need to know what are the assets of the person who passed away. Ano-ano yung mga ari-arian ng mga tao na naiwan. Meron ba siyang bahay? Meron ba siyang sasakyan? Meron ba siyang business? Meron ba siyang bank accounts, investments, shares of stocks, mga ganyan. So you need to, whoever is the person in the family, who will take charge. Kailangan niyang gawin yon. So you will do an inventory of the estate of the person who passed away. Okay, and then of course that includes gathering documents. What do you do when your family member passed away without a will? Of course, you have to look for the will muna. Siguraduhin mong walang will yung natao. Now, how do you know this? If you are the surviving spouse, when we say surviving spouse, ikaw yung naiwan na spouse, okay? So you are the one still alive. You might have an idea, or you might know, or at least might have an idea if your spouse has a will. Because sometimes it's something na pinag-uusapan ng mag-asawa. Pero kung walang asawa, sino naman kaya ang pwede nating tanungin kung may will kaya siya o wala? O yung mga immediate family members, relatives, yan, mga magulang or mga kaibigan, tinatanong natin yan. Do you think meron siyang will? Have he ever mentioned creating a will or making a will? Mga ganon. And then we also look for safety deposit box, yung mga ganyan. If they have one, if it's at home, then we try to open that. If we find the keys or however we want to open that, because sometimes the document is there, or the important documents are there, so you'll know if there's a will or not. And why is it important for us to know if there's a will or not? Because so that you know how to proceed with the settlement of the estate of that person. Minsan naman, if mayroong safety deposit sa bank yung namatay, we ask the court to issue an order allowing us to open the safety deposit kasi hindi basta-basta bubuksan ng bank yan. So we still have to apply for a court order in that matter so we can open. And then after that, okay, kailan mo rin ngayon alamin kung sino-sino yung mga legal heirs nung tao na namatay. So if the person passed away as a single, of course, yung mga legal heirs niyan, yung magulang, mga kapatid, pamangkin, or if may mga anak siya, yun yung mga hanapin mo. You have to get their names because you will need their signatures later on when you start the probate process, So, yun yung mga task mo. Now, if the person passed away is married, of course, tignan mo yung surviving spouse, at saka if they have children or grandchildren, yan. So, yun yung mga next of kin, yung mga legal heirs. Kailan mo malaman yan. And then, of course, by the way, when it comes to the estate, you're not just looking only sa estate niya dito sa Texas kung dito siya nakabase, You'll also need to know kung may mga property siya outside the state or outside the country. What does it mean to probate an estate? Yan naman ang susunod nating tanong na pag-uusapan, What does it mean to probate an estate? We've been talking about probate, probating the will, probating the estate. Ano nga ba ang ibig sabihin ng probate? Well, when you say probate, it's actually a legal process. So it's a process in which the court is involved. Okay, because why is the court involved? Because the court, you'll have to have the court legally recognize the death of a person, and also to oversee the distribution or the management of the estate of the person who passed away. For example, payment of debts, yan, liquidation of assets, and distribution of the estate to the heirs. Kaya nga importante rin na malaman kung sino ang mga heirs, kasi sila yung mga tatanggap ng estate ng taong namatay. So that is probate. It's a legal process that involves the court, because the court will have to recognize the death of a person, of course, and make sure that the asset or the estate of the person who passed away will be managed by the administrator. And because there are assets left, or kung mayroon mang mga utang pa yung namatay, let's say for example yung funeral expenses or medical bills, yan, or loans, yung mga mortgages, yan, then somebody needs to take care of those, right? Somebody needs to manage the estate of the person who passed away. And that is why we have this thing called administration. Ang tawag doon ay administration. So you go to court and ask the court, this the estate of this person needs to be managed, so we need to have an administrator. Okay? And there are two types, basic types of administration in Texas, which means also two types of administrator. We have dependent administration and independent administration. Ang pagkakaiba lang, of course, niyan, basic difference ng dalawang yan is when you say dependent, yung administrator na i-appoint ng court to manage the estate of the deceased person will have to, from the word dependent, will have to ask the court for permission or ask the court order, kailangan ganyan. Hindi siya pwedeng, cannot make a decision without the approval of the court or without a court order. Contrast naman yan sa independent administration. Sa independent naman, ikaw nang bahala. You don't even have to ask permission from the court. Most of the decisions, you can do it on your own as the administrator of the estate of the person. So if you want to sell the property, you can do that without a court order because you are an independent administrator under an independent administration of the estate. Question is, how do you start a probate process? When start, let me give you an overview of the probate process here in the state of Texas. So when you look at the slide, you'll see there the two things at the bottom. It says small estate and big estate. Okay, meron ba tayong in between? Not really. So it's either your estate is small estate or big estate. So usually if your estate is small, you can do a small simple probate. Okay. Now, when we say small estate, we're talking about an estate that has a value of less than $75,000. So, ang gagawin mo, kaya pag may mga nagka-consult yan na, attorney, kailangan ko ba talaga ng probate? Kasi maliit lang naman yung property ng naiwan ng husband ko eh. Ganon. So, kailangan pa ba ng probate yun? So, syempre, yung tatanong ko, well, gaano kaliit yung asset, yung estate, di ba? Kasi like I said, if it's less than $75,000, then we can do a simple probate for that matter. But if it's more than that, then we might need to do the full probate process. Okay? So when we say simple probate, we will just execute a small estate affidavit. And then we use that small estate affidavit to transfer ownership of the real property from the person who passed away to the heirs. But in order for you to do that, you'll have to do an inventory of all the assets of the person who passed away. And then i-add mo lahat yon. And then ito total mo, kailangan hindi lalagpas ng $75,000 at kailangan wala ring naiiwang utang. Kasi kung may maiiwang utang, then you will need an administration. kailangan i-manage yung utang na yon, kailangan bayaran. Kung may mga loans, yan kailangang bayaran. So kailangan ng tao na magma-manage. So pagka ganon, kahit na small estate pa yung property mo, kahit na less than $75,000, 'pag may mga utang na kailangang bayaran, may kailangan i-manage yung estate, you still have to ask the court to appoint an administrator. So, it's either independent or dependent administrator 'yan. So, papasok ka pa rin dun sa probate process na yon. But, if it's just less than $75,000 at walang utang, walang kailangang i-manage, um, then you can just do a small estate affidavit. But in order for you to do the small estate affidavit, you will need to find all the heirs because you will need a signature of all the heirs on that small estate affidavit. Sinabi mo namang big estate. So, it could be more than 75,000, di ba? Big estate yon. Uh, pero pagka sobrang laki, you'll have to think about paying of estate tax. Walang estate tax here sa Texas, but there is a federal estate tax which is 40% lang naman, no? But sa ngayon, ang ano natin, ang exemption diyan, ang exemption natin diyan, or the ceiling amount, I believe it's ano ba, 12.5 na ba or 11 point something million. I haven't checked the last the value kasi every year nagbabago yan eh. So ibig sabihin, if you don't have let's say more than 11 million, then you don't even have to think about the estate tax of 40% because hindi mag-apply yon. Okay? So well, usually that's part of the estate planning, but during the probate, ito na, when you start probate, when the person passed away without a will, dalawang action agad yan, dalawang pleading. Sometimes pinag-iisa ko na, pero you have to do determination of heirship, that's one, and then the appointment of either dependent or independent administration, and issuance of the letters administration. And then there's a probate hearing pa. So you'll have to, during the pandemic, we did a lot of Zoom hearing, but now we're starting, a lot of the process are done in court na. So then you'll have to go to the court and attend the probate hearing for that matter. For the two application, yung sa determination of heirship and yung sa appointment of an administrator. Yan. So, and then, pagka natapos na yon, let's say natapos na yung hearing ninyo, meron ng court order, hindi pa natatapos doon kasi yung na-appoint na administrator will have to start doing the work. Okay, so ang gagawin niya, we'll have to do an inventory of the properties of the person who passed away. So you're able to determine who are the heirs. And now you should determine what are the properties. And then kung may mga utang kailangan bayaran, kung may mga loan or anything that is related sa estate ng namatay, then you'll have to do it. You have to manage it. That's why you are the administrator. And then pagka lahat na nabayaran, yung remaining properties or assets will have to be divided among the heirs. And remember, our discussion last episode na hindi naman pare-pareho, hindi equal sharing yan lagi. It depends on who is the heir, what is the relationship of that heir doon sa namatay. Okay, so that's why it's important, if you are going to be an administrator, you have to consult an attorney kasi you want to make sure that you're doing the right thing. What exactly is a will? We keep on talking about a will, that is important, that is part of estate planning. It's a document, of course, it has to be in writing. So basically, well, all those are correct. We just want to be more specific today. When you say what exactly is a will, we're talking about a legal document. It is not just any document. It is an important document, a legal document, and if it's done properly and it has complied with all the requirements of the law, it can be enforced. The other thing that you need to know about a will is that it is not irrevocable. When you say it is not irrevocable, it's the opposite. The opposite is what? Revocable. That means you can change it. Pwede mong palitan yon. You can change your mind. All right. The other thing that you need to know exactly about a will is that it is not just about assets and properties. Because most of the time, naisip natin, ano, if it is a will, yeah, it's where you put how your assets or properties are going to be divided among your beneficiaries when you pass away. No, it's not always. It's not just assets and properties that is involved in a will. You have to have you can put some other wishes there in a will. There's a reason why it's called a will, because it is your will. That's what you desire. So it's the desire of the person um that will be enforced when the person passed away, not while he's alive, not while that person is alive. The document, the will, you create it now while you're still alive, but it will be enforceable. It will take effect upon the death of that person. Okay. Now, the good thing about having a will is you get to decide who's going to get what of your assets. So, you want to give all to your best friend? Go ahead. Why not? You want to give all your assets to your parents? Sure. Why not? You can put that one in your will. So, that is your will. That is what you want. That is your desire. So, you get to decide. That's one benefit of having a will. You're not allowing Texas to make a decision uh, when it comes to the distribution of your asset or estate when you pass away. The other thing is, you can also designate a person who will manage your estate when you pass away. And we call this person an executor, or if it's an executor or an executrix, that's the executor is the person who's going to be managing your estate, who's going to go to the court and have your will probated, be appointed by the court as the executor of your will, and make sure that the wishes that you put in your will be followed. Who can make a will? Well, actually, if you have a legal capacity to enter into a contract, you can make a will. So if you're 14 years old, no, you cannot make a will yet in Texas, because you are not yet legally capacitated to enter into any contract. So you can't make a will yet. What are the types of will here in Texas? We have, well, I already mentioned earlier the joint will, and I kind of discussed a little bit about that, which I said I don't really recommend. The other two types, we have the holographic will and the um, formal will. Okay, when we say holographic will, ito yung it was written purely in the handwriting of the person who's making the will. Purely, hindi yung tinype mo yung kalahati, you type it, and then pag-isip-sip mo, ay, mayroon pa pala akong dadagdag. And then you just handwrite it. So, hindi pwede. It has to be entirely written by the testator, yung handwriting mo. Because when we probate that will, we find we need to present witnesses who can attest that that is the signature of the person, that is the handwriting of the person who made it. You know, but of course, holographic will, it's not required to have to have witnesses. Sa Texas, di ba, 2 witnesses ang required. If it's a holographic will, hindi kailangan ng may witness, hindi rin kailangan notarized. So it's just you making your will. Eh, ang dali naman pala, sabihin mo, no? I'm just gonna go ahead and just write it. Pero matipid. Hindi na, tsaka kung ano yung maisip ko, talagang yun ang gusto ko. Yes, of course, why not? Because holographic will is a valid will here in the state of Texas. The only problem with that is later on pagka we probate the will na. Okay, because holographic will is usually yan yung mga contested will. Why? Because, the way you wrote your will, the words that you use, may have different meaning to the reader, not necessarily to you. Your intention may be different from what you've written there. So that's why it's a rich source of contest or will challenge ang holographic will. So you have to be very careful when you're writing your, if you decide to do a holographic will. And the other one, of course, is yung formal will. So when we say formal will, ito yung typewritten will. And of course, if it's a formal will, the requirement of the law is that it has to be, you have to have two witnesses, and it has to be notarized, because the notary public is witnessing the signature of the witnesses. That they're the one, and of course the testator. So it's important that you comply with the requirements of the law. Otherwise, it will be invalidated and you'll have more problem later on, and it's gonna be more expensive to resolve the issue. So you want to do it the right way the first time. What should you include and not include in a will? We were talking about this a while ago, diba? Like, ano ba yung mga pwede kong ilagay sa will ko and hindi pwede? Because we said that, well, it's my will, so I can put whatever I want, right? Yes, of course, you can put whatever you want in there. But the question is, can all of it be enforced by the court? That's the question. So that's why we're talking about this. What should you include and not include in a will? So, una yan, you look at the properties and assets. May mga properties na you cannot include in your will. And ito yung una, or properties or assets. If let's, like, for example, I put the joint tenancy. Ang joint tenancy kasi, that means dalawa kayo doon na owner nung property, right? The other thing is living trust. Of course, living trust. That's why yung mga iba sabi nila, oh, I'm just gonna have a living trust because it doesn't go to probate. And that is true, because meron ka nang dinesignate na beneficiaries doon sa trust mo. Okay? So, hindi na yan papasok sa probate, unless, of course, yung trust mo, ang beneficiary niyan yung estate mo, then papasok pa rin. So, those are just a little complication. But generally, if it's the property of the trust, you cannot include it in your disposition in your will. Okay? Now, the other thing is life insurance proceed. Bakit hindi? Because nagda-designate ka na ng beneficiary mo doon sa life insurance mo. So when you pass away, sa beneficiary mo na yon, hindi na yung papasok sa estate mo, sa yung property mo when you passed away. And then the other one, pwede kang maglagay, di ba? You can put instructions, as to what are your wishes doon sa will mo. But yes, I put here funeral. Although, yes, technically, pwede mo namang ilagay doon eh. Let's say, for example, upon my death, I want to be cremated. Okay, and I want my urn to be placed in our family mausoleo in the Philippines, somewhere there. Although, pwede naman yun ilagay mo doon. I don't really recommend that. What I do is I create a separate legal document, and it's titled disposition of remains. You know why? Kasi if you are gonna put your funeral instructions sa will mo, hindi pwede, not until the will is probated, hindi nila pwedeng enforce yung sinabi mo doon in terms of your funeral. So, what's gonna happen to your remains? Maghihintay ba yung remains mo hanggang matapos yung probate? 'Di ba? So, paano kung natagalan yung probate kasi may mga contest? It got complicated. Tumagal ng more than 3 months, or naging 4 months pa, naging 5 months pa. Nangyayari ba yun? Yes, nangyayari yun. Even 1 year pa. So you don't want your remains to be waiting, right? So that's why it's important for you to have a separate disposition of your remains. That's why I put it there. Now, don't include the funeral. You can just actually refer it there. Let's say, for the disposition of my body, I have an independent or separate disposition document. So yun, i-refer mo lang yung ginawa mong disposition of your remains, but not, wag naman doon sa will mo. Other things that you should not include in your will, nilagay natin dyan, conditions. Yeah. Yung mga conditions, ito talaga. Syempre, because some people, may mga trust issues din sila, di ba? So even parents, I will give everything to my son if my son will not marry so and so, yung girlfriend niya ngayon. Can you put that one in your will? Of course not. or divorce. Pagka nag-divorce, divorce na ako, hindi ko, hindi ko siya bibigyan or something like, because um or religion. Pag hindi siya, let's say for example, sabi mo, oh, I'm gonna give her all of my estate if she will convert to whatever religion you want her to convert to. Pwede ba yun? Of course, no. You cannot do that. Because why? Sasabihin mo, well, I can put whatever I want. Can I? Yes, like I said, you can put whatever you want, but the question is, will it be enforced by the court? Of course not. So why include it there? So how can you make changes in a will? Okay, like I said earlier, you can create your will, and the will is not irrevocable. That means the will is revocable. You can change it while you're still alive and you're capable of doing it. You're capacitated mentally. You can change your will. Now the thing is, some people, about there are two types of wills. We have here that I mentioned. So Texas, we have the holographic will and the typewritten will, the formal will. So let's say typewritten will, formal will yung ginawa mo, it's witnessed, it was notarized. Yeah. And then you change your mind. Some people and I've seen this happening, I've seen wills that are being probated na ang ginagawa nila, they cross it out. Oh, they cross out the name of the person on doon sa will nila, and then they write another name on top of it. Don't do that, please. You cannot change your will by doing that. It's not effective. It will not be recognized. Kung ano yung sinulat mo doon, it's like as if it's not there. So kung ano yung cross out mo, siya pa rin yung nandoon, because that's not how you change your will. So, and how? So the question is how. So first one, we have two ways. First one is codicil. So these are Texas, sometimes we call codicil supplementary will. That means you create another document but that document, you put there your changes, kung ano yung mga gusto mong palitan na provisions doon sa will mo na nauna, or gusto mong idagdag, ilalagay mo doon. But that codicil in itself is a will. That codicil is a will in itself. That means it has to be, you have to have two witnesses again, and it has to be notarized. And it could be probated independently, or kung na-invalidate man yung una mong will, the codicil will be your last will. So that's why it has to comply with the requirements of the law also. Now the other way of changing it is just completely making a new will, and then put in that new will that you are revoking any old wills that you've done in the past. Kasi that new will supersede or revoke the previous wills that you have created. So especially kapag you have a lot of changes that you want to put into your, sa will mo, you want to make in your will, there's a lot of changes you want to do. It would be better for you to just create a new one than just make codicils. First question we want to address, or we want to discuss as we start this podcast, is a question: do you have to probate a will in Texas? That's a good question. That could also be a question in your state or jurisdiction. Just because you have a will, do you have to actually go to the court and have it probated? Do you have to do it all the time, or are there instances where you don't need to go to court and probate a will? So that's a question that I'd like to discuss with you today. Generally, there is actually no requirement that you have to go to court and you have to probate a will. You go to the process of probate. Wala namang ganon. There's no general requirement that you have to do that. You have to go through the probate process. Kaya lang, if the person passed away with a will and there are some properties to be distributed to the beneficiaries, then you will need to go to the court and have it probated. Why? Because you can't execute whatever is on the will of the deceased person if the will is not yet probated. Why? Because the probate process will actually determine whether the will is valid or not. So if the will is not valid, then definitely you can't enforce the content of the will. It's important to have the will probated so that you can apply, or you can actually distribute the property, the estate of the deceased person in accordance with the will of the deceased person as written in his will. So importante yon. Kaya kung ang tanong ninyo, do you have to probate a will? Not always, not all the time. It's not, you're not required. But of course, if there are assets to be distributed, yes. Yung deceased person passed away with nothing left in his estate. Like for example, anong ginawa niya yung will, meron siyang house, meron siyang bahay, meron siyang mga sasakyan. But and then he executed a will, and sabi niya, all this property, all my asset will go to my one and only child. Okay. And but by the time na the person passed away, wala na yung bahay kasi binenta na niya during his lifetime. Wala na rin yung mga kotse kasi either binigay na niya sa ibang tao, or binenta niya na rin. So at the time of the death, wala na siyang property. So then there's no reason to go to court and have the will probated. What is a monument of title? So ano ba itong monument of title, and how is it related sa mga questions ni Rusty Lopez? Kasi remember yung question niya, una, do I need to probate a simple will? The second question niya, what will happen if I do not probate the will? So I think the second question that will be for at our third slide. So I'm gonna wait for that before I answer your question. Okay. So what is the monument of title? Now, let me tell you this. If a person pass away with a will, okay, tinanong natin kanina, kailan ba dumaan yun sa probate lagi? Ang sagot natin, it depends on the situations. And sometimes you don't even have to go to probate process, the full probate process. Sometimes you can just do a monument of title. So now at least you have an idea, ano itong monument of title. That could be an alternative, diba? That could be another way to probate a will, but you're not gonna go through the full probate process. Okay, so ang monument of title, ito yung you still have to file an application in court. The only thing that this is a simple way of probating a will. So siguro yun na lang masabi natin. A simple way of probating a will, ang monument of title. Although simple lang yan na process, you can't really do it on your own, like yung pro se, yung I'm just gonna do it on my own. I'm just gonna file an application in court, for a monument of title. No, because it requires an attorney to help you, or to file, or to proceed with this kind of probate process. It's this process is very simple, pero may mga specific requirements niyan, and kaya lang nga syempre you will need an attorney to do that. But still, it could be it is a simpler process than the full probate process. Ngayon, not everybody is, of course, it's not always that, oh, okay, sige, mag-monument of title na lang tayo. Hindi naman laging ganon. It depends yon. May requirements naman ang batas in here in sa Texas. And if you see, it says they're debt free. In order for you to avail of this of the process of monument of title, kailangan yung deceased person pass away without a debt. Debt free dapat siya, so wala siyang utang. Wala siyang mga loans, mortgages, or credit card, unpaid the bills, ganyan. So, debt-free. Ibig sabihin lang yung wala ng mga babayaran pang iba. And the reason for this is because kung may babayaran ka, then you will need an administrator. You need somebody to administer the estate. It could be the executor named in the will, or if there's none, or the executor doesn't want to do the job, then you will need to have somebody appointed by the court to administer the estate. And that is isa sa yun sa mga requirement na dapat there's no need of administration of the estate. Kaya nakalagay doon debt-free and no need of administration. Kasi nga naman, if there's a need of administration, then you're gonna have to go through the process of probate, because you will need somebody to be appointed by the court to execute the will if the person is named in the will as executor, or as an administrator, either dependent or independent administrator, depending on the situation, on or the heirs, whether they want a dependent or independent. So this monument of title is actually an alternative, an alternative process, a simpler way to probate a will. Um, ano naman dito ang pag sinabi mong monument of title, ang ibig sabihin lang niyan document or instrument. So, it's kind of similar with affidavit of heir, no, I mean, it's similar to um, affidavit. No, pag if the person passed away without a will, ano, sometimes you avail of a simple probate process. Pag if the person passed away without a will, ginagamit natin yung small estate affidavit. Ito naman ang parang counterpart niya pag ang tao naman namatay with a will. We do a monument of title, so which I just mentioned. It means a document or instrument. Ang mangyayari diyan lang, it becomes another document. Yung monument of title becomes another document in the chain of title ng real property mo. You can only use this one for real property, not for personal property. So it's like I said, it's similar to small estate affidavit or affidavit of heirship pag a person passed away without a will. The requirements is there must be a valid will. So again, that free yung tao, yung deceased person, and then there's a valid will na iniwan niya, and there's no need of administration. Now, the requirement is a valid will. So how will you know if the will is not valid? Kaya nga, probate process pa rin siya. You still have to go to court and apply for a monument of title, where the court also will look into the will if the will is valid. So kaya kailangan mo rin ng attorney to do the process. For the monument of, it may be simple, but at least you don't have to the heirs did not have to go to the court, or the beneficiaries did not have to go to court and appear during the hearing. The attorney can do the process on his or her own. So if, as long as you can show that all these three requirements are present, then you may be able to avail of the process of monument of title. What happens during probate? So ito na yon. I'll give you a snapshot or an overview of what's happening during a probate. When I say probate, I'm talking about full probate, okay? And then of course here you will have an idea how long does it really take for probate, ideally, realistically, or the what ifs, yung mga alternative scenarios, ganyan, like when there are some complications. All right, so of course, nagsisimula yan, not really sa filing, I just put their filing. Pero syempre, the start is, of course, you need to find out first if the person passed away with a will. What's gonna happen here now is, of course, you have to filing in court. You have to file an application to probate the will, and of course, you'll have to submit the original will to the court. Okay, once nalaman mo na which court is handling your probate. And then there's a posting here because it's required that whenever there is a probate, whenever there is an application to probate a will and have an executor be appointed and letters testamentary be issued, then it has to be posted. There is a 10-day posting period required. So after the posting, when we say posting pala, it is posted doon sa courthouse. So there's a designated part in the courthouse where they post it. So may you'll see yung mga notices ganyan. So yun. So after 10 days, tapos na yung posting, saka ka pa lang pwedeng mag-set ng hearing for prove up. Ngayon, hindi ka naman basta-basta mag-set ng hearing for prove up kung hindi mo pa nahahanap, hindi mo pa yung executor mo is hindi available, so you'll have to look into the availability ng court, ng executor, and of course, syempre ng attorney probating it. So kaya it depends then sa time period as to hearing. When sa hearing naman, of course, the executor or the applicant, the named executor or the administrator, yan, will have to be present. Now, the hearing, mag-a-appear ngayon yung applicant, yung executor or administrator na nag-apply as an administrator, and then you will prove the will, that the will is valid, that the testator was capacitated at the time he or she executed the will. So then it, of course, it complied with all the requirements. There are two witnesses. Yeah. So once the probate is done, the hearing is done, and the court approves, okay, the will. So then the court will now issue an order that probating the will. After that, of course, the court will also include the order will also include the appointment of the executor or the administrator. And after that, the executor or the appointed executor or administrator will have to execute an oath. Yun, that's why there's an oath. And then you'll have to publish yung letters testamentary appointing the executor administrator. Why? Kasi to notify yung mga creditors, yung may mga claims sa estate. And also notice yan, let's say yung creditor mo, may mortgage paying property, you have to notify the creditor kasi it's required. Para if ever they have a claim, they can file their claim now doon sa appointed executor. And then within 90 days from the appointment, from the court order, kailangan mag-submit na kayo. Natapos mo na yung inventory. Inventory is when you know inventory all the assets of the deceased person para malaman mo kung ano yung mga nasa estate niya, and then pay the necessary yung mga utang, bayaran mo, and then whatever is left, that's the one that you're gonna have to distribute according to the will of the person. So nakalagay dito bad handwriting. One common mistake is bad handwriting. Why would this be important? Well, kasi I'm saying this because I've seen will na it was handwritten. Wala nang problema sa na sinulat mo siya. Ang problema kung hindi namin mabasa. Kung iba yung basa ko doon sa sulat mo, sa basa ng iba. Nangyayari ba to? Of course nangyayari ito, 'di ba? Akala mo R, yun pala N. And why does it matter? Kasi minsan yung pangalan, no? Yung letter mo, iba yung nakalagay doon, or it doesn't look like it is, then pwedeng i-contest nila yon. Sabi nila, well, that's not you because your name has a letter R and this one is a letter N. So pwedeng ganon. But can it be resolved? Maybe yes. It'll take a while, or more evidence, witnesses, yan. So, mas kaya nagiging yun, it's one of the common errors or mistakes. The other mistake or error is if you don't dispose your entire will, if you're not disposing your entire estate in your will. What does it mean? Let's say may mga properties ka sa Texas, and then may properties ka din sa California, and then when you wrote your holographic will, nang nasabi mo lang my properties here in Texas. So then in California, you pass away without a will. Kasi in your will dito sa Texas, you did not include the properties in California. So, iba na naman ang probate nila doon. Ibang process na naman yon. So, that's why nagiging common mistake kapag ang iniisip mo lang, dito lang. Or hindi mo na isama lahat yung mga properties mo. The other one is disposing estate that no longer exists. So, sinulat mo doon sa holographic will mo na, I'm giving my Nissan Sentra 2022 to my nephew, Jerry, and then yung pala nabenta mo na yung car na yon, or when you pass away it's no longer existing, or hindi pala sa iyo nakapangalan yun.